employer relationships. You will note that the High Court actually has a division that deals with those cases. But we thought if it's just strictly what do you owe me, what do I owe you kind of dispute, it can still go before the Small Claims Court, and the Small Claims Court's commissioners can have jurisdiction then to entertain those. The more complex cases that involve other issues outside the issue of owing money can still go back to the High Court Industrial and Labor Relations Division. So that we thought that proposal could help our operations. The proposal in repealing Section 6, which relates to the appointment of commissioners, you note that the current law allows the judiciary to draw from private legal practitioners to sit as small claims commissioners. So currently, the bulk of our commissioners come from private legal practitioners. So the proposal was that we give the Chief Justice, the Honorable Chief Justice, the power to designate a judicial officer to sit as a small claims court commissioner. This was necessitated by the fact that I think in about 2023 there was a policy decision that was made by the judiciary to expand the small claims court beyond. Currently it just sits in two provinces. It's in Lusaka and it's on the Copper Belt. So stations are 3 at Lusaka, Ndola and Kitwe. So in 2023 the decision was made that we expand, but that expansion has been hampered by the fact that we do not have private legal practitioners in most of these other provinces. If they are there, they're very few, and some are unwilling to sit as commissioners. So we thought to now cure that mischief, the Chief Justice can then, in those provinces that do not have legal practitioners that are willing to sit as commissioners, the Chief Justice may simply designate a judicial officer who's already working for the judiciary to then sit as a small claims court commissioner. Then it would be easy then to expand in the other provinces, because you could easily check if there's no private legal practitioner willing, you designate a judicial officer. So we noted that the proposal was a bit restrictive. It said designate a judicial officer. The definition of judicial officer is for purposes of our proposal, is a bit restrictive, because we have other legal practitioners within the judiciary that are not captured by that definition. A case in point is research advocates. We have research advocates in the judiciary, some very senior at the bar, more than 10 years at the bar, so they are very capable of sitting as small claims court commissioners. So we thought our proposal, if you note from our memorandum, we were saying that Clause 6.3 be amended to read, the Chief Justice may, by gazette notice, designate a judicial officer, and our proposal is, we say, or legal practitioner employed by the judiciary to then carry out the functions of commissioner. That then captures those legal practitioners within the employment of the judiciary that are not captured by the definition of judicial officer. As I've just indicated, we have research advocates who are capable and can sit as commissioners. This also, like I've indicated, in most provinces we have, in fact now in all provinces we have research advocates, so they should be able to double or, if designated, sit as small claims court commissioners. There's also a proposal to deal with the tenure for commissioners. Currently, the law doesn't give a period or a tenure for the commissioners. What we've noticed is that some commissioners have not been consistent in their sittings, and then there's been, because there's no duration at which point you decide whether you want to carry on with that commission or not. So we're proposing that they are appointed for a term of 5 years that is renewable depending on their performance. We think that would then help us just deal with those commissioners that are serious with their work. Of course, not saying that they're not serious with their work, because remember, we're drawing from private legal practitioners, so they've got other chambers that they are manning, their own law firms. So understandably they could be a bit held up or a bit busy to deal with small claims court matters. The bill also proposes that we almost expand the nature of persons that have audience with the small claims court. Previously, companies or corporate bodies would only appear in the small claims court as defendants. They couldn't commence an action in their own right. So we thought this defeats the purpose of the court, because then you have SMEs that have no access to to the small claims court. They only appear as defendants. But if they themselves are being owed money within that range, they can't sue. They can't come to the small claims court. So we thought then that definition, I think that the bill actually says a person, which includes those incorporated and incorporated, so that both of them will have audience. The proposed clause 13, or is it, I think you may ask the question, who then represents them? I think the law then becomes very clear that any one of the directors, because remember, we do not allow legal practitioners in the small claims court. They have no audience, so that the processes there are not fraught with technicalities. So we've indicated in the next proposal that then those companies will be represented by their directors or somebody from within the company. So in a nutshell, Honorable Chairperson, those are some of the key issues that I thought I can highlight from our memorandum. Safe to also indicate that this bill does constitute substantive legislative amendment to the framework governing the small claims court for the reasons I've given. But we are indicating that by refining statutory definitions, broadening the court's jurisdiction, and enhancing administrative efficiency, we will make sure that the small claims court operates as smoothly as can be. I thank you.
Thank you for the presentation, honorable members. Yes, Honorable Chunkudi.
Thank you, Chair, and our witness, thank you for your submission. I just want to make, to clarify on the issue of legal practitioners. We're talking about legal personality. Are they allowed to be part of the litigation process in the small claims court? If they are not, why? And if they are, why should it be so? Looking at the motivation that brought out the small claims court, where we're talking about efficiency, reducing congestion in the high courts and the like. Chair, I submit.
Thank you so much, Chair, for the opportunity to ask a question. Judicially, currently the Act has the jurisdiction to consider up to, is it 75,000 kwacha? Kindly, could you be in a position to share what the range you are trying to look at in terms of scaling up? I know it's supposed to come through the SI, but would you be kind considerably what is the figure we are trying to look at? Thank you.
Yes, Honorable Fuga.
I didn't introduce myself. My name is Mlenga Francis Fuve. I'm a member of Parliament for Chiruvi. I think let me take advantage of the judiciary to find out on especially Section 5 that borders on if it is amended. I know that a lot of amendments, I think clauses that are proposed start from maybe from the clauses are from 2 to 20, 3 to 20, and the sections from 2 to 31. But my main interest is Section 5, which in a way touches on jurisdiction of the court, and I think it is also suggesting that it will also touch on the jurisdiction of the industrial relations labor's court. Then there is another aspect that it brings in, that of rent. So I wanted just you to qualify on whether it will also require that we need to amend the Rent Act as well as the Industrial Relations Act.
You can respond to those observations.
Thank you, honorable members, for those questions. I'll start with the first question that related to legal practitioners. So even in its current form, the Small Claims Court does not entertain or legal practitioners, for the simple reason that we tried to make the process as simple as can be, so that even a lay person can walk in and determine. You know, it's a notorious fact that once you introduce lawyers to certain things, you find preliminary objections on this and that just before on a particular document. So to avoid that, we decided to, so they have no audience, so they cannot appear to represent a client in the small claims court. Of course, a client can go to their chambers in their firms and consult them, but as they appear, that client is on their own. So it means even a lay person can walk in and represent themselves. Just to also highlight that we had the Judiciary of Kenya that came to benchmark the small claims court in Zambia maybe a month or two ago, and their biggest problem is that they've allowed legal practitioners in the small claims courts. So their biggest issue has been a lot of cases failing to move and a lot of appeals from that court. And you see, learning from Kenya, we wouldn't want to go back there. So we want to maintain the status quo. Then with regards to the 75,000 mandatory jurisdiction, you note that this was increased recently. It used to be from 0 to 20,000 not too long ago. I think a year or two ago, there was an SI that was promulgated that increased that mandatory jurisdiction to 75,000. So far we haven't had any discussions regarding increasing it further beyond the 75,000, because for now we thought the 75,000 will capture most of the cases that we're looking to have in the small claims court. And also, when one considers that this lowest ranking magistrate has jurisdiction in terms of money up to 70,000, so we think that some of those cases can still go to the subordinate courts. So we don't want to overburden the small claims court as well to very huge figures. We would rather than those go to the subordinate court. But when that time comes, we can then reconsider whether 75,000 is good enough or we need to increase it a bit further. But that will also mean we have to look at the subordinate courts. We may need to, because I think they go almost side by side, we may need to adjust upwards on the subordinate courts as well. The last question related to Section 5, which deals with the jurisdiction of the small claims court. If I got you correctly, I think the question was around whether or not our proposals will affect the industrial relations court and whether there's need for amendment to particular legislation that the court uses. We don't think so. What I could say is that, like I said, the nature of the cases in the small claims court are those that are very, very basic. It's an issue of how much do you owe me, and or do you owe me this much. So there's no question of calling for evidence. So when cases are filed, we actually help the clients that come to our courts, because we do not have cases that are complicated. It's just as simple as somebody owing somebody money. While the Industrial and Labor Relations Court, of course, goes a lot further than just looking at whether somebody is owed money. It's evidence that is being called, and there's so much that is involved in coming up with a decision in that court. So for now, we don't think there's need to amend, just because we are expanding the jurisdiction of the Industrial and Labor Relations Court.
A follow-up?
Yes, it's a follow-up question.
Or maybe we allow him to finish.
Oh, okay.
Oh yes. So in a nutshell, I think that's the point. But also that also kind of decongests the industrial and labor relations, because some of those cases that come there are in that nature where we think this should properly be heard before the small claims court. So in fact, there will be less work in the industrial and labor relations court. But we're not taking away anything from the jurisdiction of that court. Thank you.
Yeah, you can proceed if it is a follow-up. Yeah.
I was thinking that in the nature that it has been proposed, especially that I included the issue of the rent. If you look at employment and what is covered in the Employment Code Act, it means that the small claims court, if it is not going to specify which areas of employment, related to employment is going to deal with, it will be for, is it what you lawyers call forum shopping, isn't it? It is going to attract forum shopping. Because when you talk about employment, there are salaries involved, retirement packages and many others, which opens up the small claims court for forum shopping. And the fact that the small claims court is supposed to be inexpensive. Labor matters may not be as cheap as it may be. I know that the issue of the lawyer doesn't come in and the like, but they can be very draining, the labor matters. Because it's addressing, the amendment is addressing the component of employment related matters. That's why I asked about that. And I fear that this may attract forum shopping.
Yes, Honorable.
Chair, I just wanted the witness to be very clear on the issue of the current 75,000. Is it the position of the judiciary that currently the 75,000 kwacha is sitting well in the small claim? There is no intention at the moment to upscale.
You can respond.
Maybe I'll start with the last question. Yes, I think there's no current intention to upscale because we recently, like I said, increased from 20 to 75,000. Whether or not that is sufficient, I think that's a question for another day. But there's been no discussion to upscale. And that's why I also gave an example of, we have this other structure, the subordinate courts. Their mandatory jurisdiction runs from 70,000. So it's also a forum where they can go. But I was saying that should we now assess and note that we may need to increase, we have no problems increasing. But we thought, let's give it a bit of time and see how the courts are. And remember, we only have 3 stations now, so already that increase to 75 has increased the workload on our commissioners, who, like I've indicated now, are part-time lawyers. So we're trying to balance. But I think when the time is right, we'll consider that and see how we increase. And with the issue of the nature of the matters, maybe just to be clear, so even if it's an employment relationship, the question that the small claims court will be dealing with is, for example, its salaries. Do you owe me 2 months unpaid salary? If yes, the amount is, say, 40,000 kwacha. Then you go to the small claims court and say, my employer owes me 40,000 kwacha. That's a matter that can properly go before the small claims court. Of course, the issue of whether or not there was a contract of employment, that's not the issue for the small claims court. So we're looking at those very simple matters. It could even be arrears, for retirement arrears and whatnot. So as long as they fall within that bracket of 75,000 kwacha, and the question only is to how much money is owed, the small claims court will hear. If it's an issue of whether there was a contract, there was no contract, you are dismissed, and those questions, the small claims court will not deal with those matters. Those matters will now go to the Industrial and Labor Relations Court. So our officers won't even allow somebody to make a filing if the nature of the case is that, because we guide them on what matters come before the court. I thank you.
Any other observation? Yes, Honorable.
Chair, thank you so much, and thank you so much, our witness. You're making our work very, very easy. I just want to look at the critical differences from the act that we are trying to amend or repeal and the current act that we are trying to bring about. I just want to know certain features, more critical features that would differentiate the two. Looking at, for me, I was looking at his question where he questioned as to do we have intentions of bringing the figure of 75,000 upwards. But now that's not the case. So I just want to look at the critical features that would differentiate, the two statutes. I submit, Chair.
Yes.
So if I got you correctly, the proposals and the act as it is now, I think those are the ones that I'd said would focus on, because we didn't want to dwell on each and every proposal. So the first one, like we indicated, was if you look at the nature of appointment of commissioners, then you can't designate a judicial officer or a legal practitioner in the judiciary as a commissioner. So we think that is a very big change that may need your attention in terms of looking at our proposals and whether they sit right. The other one was on appearance of companies before the small claims court. The current act will tell you that the corporate bodies only appear as defendants. So right now, as it is, it's almost, for lack of a better word, it's one-sided, because they can only be sued, they can't sue. But this new proposal says they can sue also. You have a small SME registered as a company, the amount they want to get from somebody is within the range, they can also go to court. Currently they can't. So that's also a big change in terms of the current law. I think those are the ones that I could, off the top of my head, point to. But I also forgot to mention, I think it may be a minor drafting issue on clause 6 in the bill. I think 6.4, it reads, the judicial officer appointed under subsection 1 shall be appointed on a part-time basis. So whether or not our proposal sits right, what would have loved it to read was a judicial officer appointed under this subsection shall be appointed on a part-time basis, because subsection 1 does not make reference to the appointment by the Chief Justice. So it's just a minor drafting issue that I'm sure the drafters would guide whether that sits well. But we just thought it shouldn't say subsection 1, because subsection 1 relates to a different kind of appointment. So we thought we could bring that to your attention, and I think it's something that we didn't capture in the memorandum. I thank you.
Honorable members, and we are done. We are satisfied. Okay. Thank you, Judiciary, for having satisfied the members. And we are hoping for the better. Having mentioned and satisfied the members, I think we withdraw the immunity that was granted, so that you go and perform their daily duties. Thank you very much and have a good day.
Thank you, Honorable Chair, and have a good day.
Parliament TV, bringing Parliament closer to you.